This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law. Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Schnorman.
Welcome to Lawline. The recent trial and conviction of Colin Ferguson for the Long Island Railroad Massacre raised many questions on his competence to stand trial and act as his own lawyer. Today we'll look at the legal insanity defense and some of the controversies that surround it. Our guests are Ronald Kuby. Ronald is a partner of William Kunstler and a criminal defense attorney who acted as Colin Ferguson's legal advisors, one of them. And we also have Dr. Stephen Simmering. Stephen is a forensic psychiatrist with the University of Medicine of New Jersey. Hello, Ron. Hello, Dr. Simmering.
Good to be here.
First, Doctor, can you tell us what is this legal definition of an insanity? What does it mean when somebody is legally insane and doesn't have to account for what he does or she does?
Funny that you asked the doctor the legal question. The concept of insanity is like the concept of childhood. You can't hold a 2-year-old child responsible for murder or burning down a house or anything else like this. And going back to the last century in England, the idea was that you couldn't hold a person responsible for a crime if he didn't have the mental ability to understand what he was doing was wrong.
Now, does that mean you don't know what's right from wrong?
There's different formulations of the insanity defense, so-called, and it varies state by state or federal government. But in its pure form, the so-called McNaughton form, which came from England, the idea is that you had to maintain two standards. First, you had to have some mental illness, whatever that meant. And then to be legally insane either as a result of the mental illness, you did not know the nature and quality of the act. That is, I shot you with a gun, but I thought I was using a rubber gun. Or, even if I did know the nature and quality of the act, I didn't know it was wrong. In other words, if I shoot you because I genuinely think that you want to kill me, then that's okay because self-defense is okay. It's really not controversial.
Ryan, if we may, let's take that definition and transfer it over to your client, Colin Ferguson. It's been reported that you and your partner, William Kunstler, felt that Mr. Ferguson was insane.
Oh, absolutely insane. It wasn't just what we felt. We're not psychiatrists. The psychiatrist, the defense psychiatrist, examined Colin Ferguson longer than anybody had ever examined him and said, this man suffers from delusional disorder, persecutory subtype, a psychosis.
What does that mean?
It means he's psychotic. It means he's absolutely psychotic. And we all got the opportunity to watch that on national television as he stood up there day in, day out, flailed away at imaginary demons, acting like a lawyer on this utterly crazy defense, which wasn't insanity. I mean, Colin Ferguson was much too crazy to accept the insanity defense. Colin Ferguson insisted, oh, I didn't do it. Some mysterious white guy did it. He sort of beamed down from planet Caucasoid, shot all those people, and then beamed back up after stealing my gun. That's what his defense was. He was much too crazy to allow us to use an insanity defense in the first place.
Ron is saying that if he had raised the insanity defense, or he had let Ron raise it, chances are the jury would have bought it. However, when you think about it, very few people who raise insanity are acquitted on grounds of insanity, even when the public thinks they are. I mean, think about Son of Sam, Jeffrey Dahmer. You could think about Chapin. It is very rare. Hinckley is the exception.
It is very rare. I mean, the insanity defense is rarely used by defense lawyers because it's so unpopular. Juries don't like it. It's counterintuitive. People are offended by it, and it's very rarely successful when it is raised. Now, when we started this case, people said, oh, you and Kunstler are never going to convince anybody Colin Ferguson is insane. There was premeditation. He made statements afterwards indicating he knew the difference between right and wrong. But by the end of the case, after he had a chance to watch Colin Ferguson day in and day out as part of this macabre national spectacle, almost everybody was convinced he was insane.
I have to tell you something. I watched him on television, and I was very impressed with his presentation. I was impressed with his choice of words. I was impressed with his cross-examination. I was impressed with his opening statement and his closing statement. The man almost seemed that he had almost a legal education.
Intelligence has nothing to do with insanity. And that's an error to think. It's not. Some people believe that very intelligent people are all insane. And some people believe you got to be real dumb to be insane. There's no correlation. There are bright people who are mentally ill and dull people. When I told you about the McNaughton test before in England, prior to that they had a test called the wild beast test, that the only way you were insane is if you were as crazy as a wild beast. And what the McNaughton test did is humanize it. It said that there are people who walk and talk and make sense, and everything may be normal, except they have one little delusion, and that is that guys wearing eyeglasses are sent by the devil to kill them. Except for that, everything's okay.
In Colin Ferguson's case, for example, let's pretend that his delusion was that he was President of the United States. Well, he could get up there and he could make a motion to dismiss the charges. He could say, you can't try me here in Nassau County. I'm the President. I can only be tried by the Senate under articles of impeachment voted by the House. And it'd be a very compelling legal argument. And he could write a good brief and make a good argument. The only problem is, he's not the President. He is nuts. And that's why we said, look, he shouldn't have been brought to trial at all. He should have been sent off to an institution where he could have been treated for the first time, he could have been medicated for the first time, and maybe restored to a point where he was no longer delusional, where he was capable of acting in his best interest and making rational decisions about his own defense.
The problem with the word nuts, as you use it, is not so much...
It's a legal definition.
Not so much offensive, is that it is imprecise. Because there are a lot of people going around who may be... quote, nuts, as we think they are. For example, people with weird political beliefs.
It's a good working definition, though, and certainly as applied to Colin Ferguson, it has a certain resonance.
The problem is it has such a resonance, and you're so sure of it, because every person in the courtroom says the guy's nuts. The old Meshuggah test, that he meets that. The problem is that's misleading, because it misdirects you from what it really is. In the most famous insanity case of this century, probably, the John Hinckley case, there was a lot of dispute about whether John Hinckley was nuts in terms of raving and ranting. And yet the jury, in a very unusual thing, said, despite the fact that he shot the president, he met the standards for insanity. But as you say, it is rare that an insanity defense works with a jury. There are many insanity defenses, however, but everybody agrees. You know, if the prosecution, the defense, everybody, and the judge agrees, many people are sent to mental hospitals and treated humanely. But when head comes to head and it's a battle, it rarely wins.
Ryan, tell us what it was like dealing with Colin Ferguson on a lawyer-client basis.
Well, it was excruciating, of course, and I was really dealing with him not as a client, but as a colleague. I mean, he would ask me legal questions. I would give him answers. Almost all of the information I gave him was entirely technical. I mean, how do I draft a subpoena? And he was very good at absorbing the technical details. And if you forgot for a moment that the subpoena he was drafting was a subpoena for the President of the United States, you could almost convince yourself that you were talking to a very bright law student or perhaps a somewhat unskilled attorney. But none of that obscured the fact that you were dealing with a man who was in the grip of delusions. That is, he had firm, fixed, and unshakable beliefs in things that simply were not true, no matter how much evidence you adduced to the contrary. So it was extraordinarily difficult to explain to him what he should be doing.
Did you ever reach a personal conclusion of why he did what he did?
Yeah, I reached the conclusion that he did what he did because he was so paranoid and so deluded. On the day that he finally got the call about his workers' compensation claim finally being denied, he just snapped. And he went out with the gun that he had for a long time, and he wreaked absolute mayhem on that train. But I don't think he was in control of himself. I don't think at that moment he knew the difference between right and wrong. And I certainly don't think in the course of this trial he was capable of assisting in his own defense in any meaningful way. He gave us a great show, but he brought the legal system into disrepute and I think brought us all down.
What about the black rage? I kept reading about it in the newspaper.
Yeah, black rage was this tremendous media construct. You know, the nature of Colin Ferguson's delusions were racial delusions. I mean, he had delusions of persecution because he was black, often being persecuted by other African Americans. He saw a vast white conspiracy against him, and he saw it everywhere. It was a delusional system. And it was that delusional system that informed his choice of victims. It's why he shot up a train full of white commuters out of this black rage, rather than simply going to the post office and massacring everybody there, or to a McDonald's.
It's really interesting because black rage, as we read it in the the paper implied something else. It implied a whole new kind of defense. That is, if someone is so racially angry, it is a different category. What you're saying is really quite trivial in a psychiatric sense, because when a person has a delusion, it doesn't make a whole lot of difference if he thinks the whites are after him, or the blacks, or the CIA, or the mafia, or the mob, or anything else. In psychiatry, it's the form of the delusion that's important, not the specific content.
That's exactly right.
Doctor, is Colin Ferguson the same type of people, like we said, the post office, periodically, I mean, it's almost now every year or every other year we read about somebody going into a post office, a former worker, and killing 3, 4, or 5 employees and customers?
Well, I think it's a real mistake to generalize Colin Ferguson and to all kinds of people, and they vary. Surely anyone who goes into a post office and kills people has to be upset, has to be mad in the sense that they are out of control, nuts as you say. But they may be mad angry, or they may be mad insane, or they may have a grudge that they believe, or they may have a political belief, or they may be genuinely deluded, as you say that your erstwhile client was.
Erstwhile colleague.
Is anyone, doctor, is anyone capable of doing that, put in a special circumstance under special environmental problems that he may have, or outside problems, of doing what going into a post office?
Yeah, what if I were going to shoot your wife and kids?
Well, certainly I'd go to protect them.
Well, there you go. The only difference is, what if you believed I was going to shoot your wife and kids, but it was all in your head?
Of course, if I truly believed it, I would still protect them.
There you go. I mean, that's what legal insanity is about, and that's what Ron is saying. And you see, the frustration I must feel for you of an attorney, a sometime colleague, wanting to do the right thing and having both hands tied behind your back, and being reduced to dealing and aiding in what looked like a farce. Must have been very, very frustrating.
It was excruciating, and it was so enervating because the prosecutor produced this whole disgusting spectacle. I mean, he could have said, yes, let's pack Mr. Ferguson off. We'll come back in a year, see how he's doing. But he said, no, we want to have the show. And so he had his big show, and he saw this. It was almost like bear baiting up there. It was just a terrible, terrible spectacle, and it didn't help anybody at all.
So you get, though, however, to a whole different issue. You see, intertwined are two concepts which often get mixed up, but they have to be kept separate. One is what we've talked about, insanity. At the time that Colin Ferguson shot, and I don't have to say allegedly shot these people, the question was he insane? That may be one question that was never raised. The other question is, today, or the day of the trial, is he mentally competent to deal with a trial? That's a whole different
to aid
kind
and
of
assist
issue.
in his defense.
That's right. There are two prongs to that test in New York. Do you understand the nature of the proceedings against you? That is, do you know you're in a courtroom in a trial facing charges? You're not tap dancing in a Martian cabaret. Clearly he understood that. But are you capable, in addition, of assisting in your own defense in a meaningful way? And Colin Ferguson wasn't capable because he was delusional and because he was paranoid. He was so paranoid that he couldn't trust any information anybody gave him because those people were out to get him. He couldn't evaluate the evidence that he saw because he was delusional, incapable of processing that information.
Competency is a tough one, too, because while I completely agree with you, just watching it from the sidelines and sympathize with you, yet I cannot tell you how many lawyers have called me and said, Doc, my client must be incompetent because he can't cooperate. Why is it? Look at all this evidence against him, and yet he refuses to tell me what really happened when he cashed the checks, or when he robbed the house, or he falls asleep when I'm talking to him, or this or that. There's all kinds of clients who are bad clients and who are not so bright or not so sophisticated. The real issue is, does it cross the line where he literally cannot participate in his defense? And if so, can you shove an insanity defense down his throat if he doesn't want it?
You absolutely cannot.
Doctor, I'd like to go back to something you had mentioned with me with the example. If I thought that my next door neighbor was intent of harming my wife and children, and I thought it, and I did something, and I stopped it. I got a gun and I stopped it. Now, would I be temporarily insane if I was mistaken?
First, the concept of temporary insanity really doesn't exist in most jurisdictions. That's somewhat of a misunderstanding. That's kind of a Twinkie defense. I ate a donut and am I temporarily insane? That gives insanity a bad name. The real question is, if your neighbor really were intent on killing your wife and kids, really, you would still not be able to do anything. You'd have to go to the police. You cannot take the law into your own hands. So if you had that delusional belief, you're no better. The real issue is if you all of a sudden opened the door and saw your neighbor and saw a gun in his hand and shot him, then you probably would meet the criteria.
Although he may have just wanted to show me the new gun he just purchased.
That's right.
Okay,
It may not have been a gun. It might have been a garden hose.
We're going to take a break right now, and we'll be right back. You're watching Lawline. I'm Alan Schnorman, your host. Stay with us.
In a life-threatening emergency, you should know what to do. Say a loved one exhibits unusual symptoms. The first thing to do is...
Clear!
No. The first thing to do...
Oh! Tourniquet! No!
The first thing you do is pick up the phone and dial your emergency number.
Call 911 first.
Right.
How about mouth to mouth?
I don't think so. To learn more about life-saving techniques, contact your Red Cross.
Your approach is looking good, Cobra.
The men and women in the National Guard and Reserve face some tough challenges when they serve. Challenges that teach them discipline, leadership, and technical skills that make them better employees. So when they need time off to serve, don't make their toughest challenge approaching you.
Hello, you're watching Lawline. I'm Alan Schnorman, your host. Today we're talking about the legal insanity as a defense. Our guests are Ronald Kuby. Mr. Kuby is partner of William Kunstler and a noted criminal defense attorney. He represented Colin Ferguson. And we're honored to have Dr. Stephen Simmering, a forensic psychiatrist who's examined many defendants and people such as Saul Wackler. You were in the Exxon matter and a lot of other papers that I've read about you. But let's get back to what we're talking about here. We spoke about temporary insanity, and you told me that's really nothing about temporary insanity. What about the battered woman, the battered spouse syndrome? Woman is beaten by her husband, and all of a sudden he goes to sleep, and she shoots him at night.
Not an insanity defense. This has worked, and this defense has flown in many jurisdictions, but it's basically a self-defense defense. It is a variant on self-defense, not insanity.
Justification?
Absolutely.
Well, yeah.
That's
yeah.
exactly right. What that in most jurisdictions, almost every jurisdiction, you have a duty to retreat if you can, go away from the danger. And in most spousal killings, when a battered spouse kills her abuser, she was in a position technically to retreat. Why didn't you walk out the door? Why didn't you just leave? And so the battered women syndrome was developed psychiatrically, or in social science anyway, to explain that she did not perceive that she actually had an escape route. She was so abused, so traumatized, she didn't know she could leave. The door could be right there. She was incapable psychologically of seeing it, and it fills that particular hole.
Well,
but it's absolutely
you argue with it very
defense.
well. The defense, for better or worse, has become very, let us say, encrusted with political, feminist belief systems, and that's always a problem. When any defense becomes too closely wedded to some political point of view, it's very hard to maintain some perspective. I have seen cases where I believe that the battered wife so-called defense is a realistic one, where a woman has said, for example, that when she went to bed that night, or when he went to bed that night, he had said, when I wake up, that's going to be your last breath on earth, and I'm going to kill you. And she genuinely believed it, and she was so frightened that she killed him. But the point is, it's not insanity. It is a variant of self-defense.
What about this diminished capacity? What does that mean? Ron?
Well, in the law, diminished capacity, which is an increasingly unpopular defense, is designed to reduce the level of the offense, say from murder to manslaughter, because you had a diminished capacity to understand what you were doing. So your crime, while still serious and while still wrongful, is less
What if I'm
blameworthy.
drunk? Is that a diminished capacity?
I'm
on drugs.
In some jurisdictions, voluntary intoxication does qualify as a diminished capacity. In other jurisdictions, it doesn't. But again, it's something that's very, very hard to sell to a jury, unless, of course, somebody sat there and poured the liquor down your mouth as you were fighting.
It has many kinds of meanings. For example, if you walk into a bar room and you say, I'm going to get you, you son of a gun, and you walk up to somebody and shoot him, drunk or not drunk, you'd have a heck of a time selling diminished capacity. On the other hand, if a guy walks into a bar with a gun and says, damn it, and starts shooting up the whole bar and kills somebody, you might have a lot easier time saying that, yes, he was drunk, yes, he was reckless, but it's awfully hard to prove that he killed this person with purpose.
So if a person is drunk, if a person is on drugs, that is not a defense in any way to the crime.
Well, sometimes it can be and sometimes it isn't. It really depends on the jurisdiction. But it is a very difficult thing to sell to a jury that because you were drunk, you killed this person. Because you were on drugs, you killed this person, and therefore you should be exculpated. At best, if you were so drunk, for example, you lacked the intent to kill. You were so blind drunk, you didn't know what you were doing. Well, that's not murder because you didn't have the intent to kill.
No.
But it's manslaughter. You go to jail for 20 years instead of for the rest of your life.
Doctor, I've often heard that some crimes, by their very nature, people just think the person must be insane. If a person is cannibalizing other people.
Except Jeffrey Dahmer was found, Jeffrey Dahmer, the perfect person to have been found insane. Everybody said this man is absolutely nuts. Jury said guilty.
And not only that, Jeffrey Dahmer said thank you, essentially, after that happened. And Jeffrey Dahmer pretty much confirmed it was the right thing. Just because somebody does something which is so repugnant, so bizarre, so sadistic, so horrible, that does not meet any particular defense.
Legally,
and when you get right,
that's right.
legally, and when you get right down to it, if you consider something like diminished capacity, really every state and every jurisdiction has a different rule, and it really depends on what the people want in that jurisdiction. There are times in history where people are more lenient and more accepting that social pressure or deviancy should be accepted. We're now in a phase where there's a great deal of law and order and strictness and fed up with crime, and therefore the criteria are getting very strict.
And the terrible thing about the public debate around the insanity defense is people are posturing and saying, well, gee, every time some criminal has a bad hair day, he comes up with some crazy new defense and walks away. That's not true at all. What is true is almost the opposite of that. How many desperately mentally ill people are out there who are crazy, who are psychotic, who are absolutely not in control of themselves in any way, who go out and do things, terrible things, and are still legally sane, are punished by the criminal justice system when they should have been treated and helped before they committed any crime by the mental health system.
Well, you're talking about defenses, Ron. Now, I know you've handled many unpopular cases over the years. Can you discuss some of them? What areas have you represented?
People like Colin Ferguson, people such as Sheikh Omar Abdel Rahman, alleged Muslim fundamentalists.
Well, that's the plot against the tunnels. And
the plot to kill everybody and blow up everything and destroy all the world. This vast FBI plot that in fact, the government itself created.
You got some nice clients.
Well,
you invite them home to dinner?
In any case, I certainly prefer them than, say, General Motors and people, corporate executives who sit there in offices in the cool of day and make exploding Pintos.
But don't you just... But you just criticized some defenses now on the
exploding
Sheik.
Pinto defense.
Yeah, well, that's
right.
one of the defense. But on the Sheik, I mean, what was your defense on that case?
He didn't do it. He was an innocent man. He'd conspired with nobody. The man taught the Quran, he preached, he taught, and if people want to misconstrue his teachings and want to take this sort of rich, biblical, allegorical speech and take it literally, well, they can do that, and that's their problem. They are the ones who need to be restrained. But everybody in America who gets up on a pulpit and preaches is not accountable and can't be held accountable for the actions and statements of their followers.
Well, it certainly has nothing to do with insanity. It has a lot to do perhaps with free speech and with protected speech and the difference between religion.
How do you feel about it personally, what Ron said?
Well, I wouldn't invite him to dinner. I'd frankly rather have dinner with the GM guy, at least.
Well, I don't know.
Talk about the exploding Pintos.
I've broken bread with Sheikh Omar a number of times. Unfortunately, it has to be in his home, which it currently is a crummy little airless jail cell rather than mine because he's been held on preventive detention, unlike those exploding Pinto guys.
What other cases have you handled, Ron?
We represented so-called rioters in Tompkins Square Park, anarchists, communist bombers, various dissidents of various stripes.
Communist bombers?
Yeah, various underground groups in the United States during the 80s, the Puerto Rican independence groups and other white underground groups who engaged in various acts of bombings throughout the late 1970s and early 1980s.
And
No whiplash?
And the amazing thing about many of these folks was that in those cases, they put on very political defenses. Defenses that a lawyer would criticize. A lawyer would say, legally, you're committing suicide. I'm just the Dr. Jack Kevorkian of law here, helping you commit suicide. But they all made rational decisions based on political principle. To stand there and say, what I did was a good thing, what you should do it, I attacked South African installations, it's the part of the fight against apartheid. Those were all rational decisions, despite the fact that they went against good legal advice. Unlike, say, someone like Colin Ferguson, who made a decision to reject an insanity defense for an utterly irrational reason. The irrational reason being, I didn't do it, some white guy did.
And you mentioned Jack Kevorkian. There's the best example of all. Here's a doctor, my colleague, who I have to say I admire in a certain way, who is trying to blaze new ground and saying what most physicians don't have the guts to say, that at the time of the moment of death, there had to be decisions made, rather than just spending millions and millions of dollars in fruitless exercises. This is a challenge to the system. We live in a free country, after all, and you should be able to challenge the system. But I agree with you. With Colin Ferguson, when you have a man who just doesn't make any sense to you, that it is no principle, that this isn't black rage, this is nothing, it must be awfully frustrating. And yet, people are presumed to be competent until proved otherwise, and it's awfully difficult. Short of a guy coming on there and just raising a ruckus, it's awfully hard to prove that a man or woman is not fit to proceed to trial.
Colin Ferguson, the case is now on appeal. Is that one of the issues that he actually wasn't
No,
saying?
of course not. Of course not. I mean, the only sane thing that Colin Ferguson could do would be to allow us to raise his insanity on appeal, and therefore, true to form, he won't allow that ground to be raised at all. So we can't raise his legal competence. We can raise, and he can raise, or whoever does this appeal can raise things like the judge wouldn't allow Colin Ferguson to handle the gun in front of the jury, or the evidence was insufficient. Colin Ferguson's own crazy views of what's appealable, but he will not allow that ground to be raised. And a defendant, I mean, a competent defendant is deemed the master of his own defense and can reject an insanity defense completely, as he has done.
Actually, technically, in many jurisdictions, that the only way someone can be forced to take an insanity defense is if he literally doesn't know what the defense is. Like if he doesn't know that there is such a thing, or he tells his lawyer, oh, an insanity defense would get me executed in some dungeon or something. But as long as he can say, yes, I know what an insanity defense is, that's for crazy people. That ain't me.
And in New York State, you have an
that's
absolute right to reject it.
But Doctor, what I don't understand is that's all part of his delusions.
That's right. That's exactly right.
So how could obviously this very sick person be prosecuted as a person who was not sick at all?
Because at the time he was tried, it was determined, right, wrong, or indifferent, that he understood that there was a trial going on and that he was able to confer with counsel. Ron says that he really wasn't. He seemed to be, but wasn't. That may be true.
Well, because it's not simply conferring with counsel. It's assisting your own defense. And assist isn't just, please hand me that piece of paper.
Quick wait. Ron Kuby, thank you very much for appearing on Lawline. Dr. Simmering, thank you once again for appearing on Lawline. It certainly was a terrific show. And as always, this is Alan Schnorman, and thank you for watching Lawline.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law.